Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, can you imagine being raided by the FBI on a warrant all because they got the wrong address? Can you imagine having the ATF just kick your door in and take your family outside at gunpoint because they're operating on terrible information? Not like that. Oh, that's right. It did happen. Actually, it happened to this guy right here, Mark Manley out in Maryland. Can you imagine that happening to you and you not being able to do anything about it or having no recourse after it happens? Well, that's the way the people in the 11th Circuit live right now, because according to the 11th Circuit, there really is no cause of action against these people. But now the United States Supreme Court has a chance to stop that insanity, as they have accepted review on a very, very important case that we're going to spend a little bit of time and geek out about. So today, let's spend a few minutes and let's talk about, can you even sue the ATF or FBI if they unlawfully raid your home? Okay, listen real quick before we get going down the road we're going down. Proud to announce that this video is being brought to us by our good friends at the Sonoran Desert Institute. That's right, get ready to launch your career in the firearms industry today through education. Get ready to start arming yourself today through education. And most importantly, get ready to start defending the inalienable rights of millions of Americans nationwide, all through our most powerful act, which of course is education. Listen, SDI has a program, a certificate, or a degree for just about anything that you may be looking for. So if you're finally ready to make that career change, if you're finally ready to launch your career in the firearm industry today, check them out in the description box below, or easier yet, just visit them at sdi.edu. Okay, America, the case we're talking about today is Martin versus United States, a case that was just accepted for review by the United States Supreme Court. This stems from a horrible incident that took place in 2017, that's right, 2017, in the state of Georgia, where a bunch of FBI agents just showed up at the home of Martin, kicking the door in, throwing in flash grenades, and removing the whole family at gunpoint, all because they had a warrant. They did have a warrant for the house a block down the street. Oh, and their excuse for how they ended up at the wrong house, because I'm not talking about it was like the next door neighbor's house. I'm talking about a house that was literally a block or 2 blocks down the street. How did they end up at the wrong house? Oh, apparently through faulty GPS. What you're going to learn about today, briefly, is the Federal Tort Claims Act found in 28 United States Code Section 2680. Essentially, this is a statutory workaround to sovereign immunity. What is sovereign immunity? Well, anytime you guys are asking me, why can't we just sue these legislators for passing these blatantly unconstitutional laws? Why can't we just sue the ATF for clearly writing unconstitutional rules? Well, the answer is due to sovereign immunity. But the purpose of the Federal Tort Claims Act was to actually allow individuals a cause of action against government agencies when they completely drop the ball, as they did in the Martin case, and as they did in this case right here involving our good friend Mark Manley out there in Maryland. Now, if you reside in any circuit other than the 11th Circuit, yeah, you probably and likely have a very good cause of action against the FBI in a case like this. But in the 11th Circuit, no. That's because the 11th Circuit, for some reason, has decided that they are going to interpret the Federal Tort Claims Act in an entirely different fashion than any of their brother or sister circuits. Now, as I mentioned earlier, and you need to understand this, the 11th Circuit has come up with an incredibly novel way of looking at FTCA. And as the petitioners, when asking for review by the United States Supreme Court, pointed out in their petition, first, the opinion below holds that claims within law enforcement proviso to the FTCA, a federal statute, are barred by the Supremacy Clause because the mistaken decision to raid the wrong house has some nexus with furthering federal policy. That's right, they were trying to serve a lawful warrant somewhere. They just happened to get the wrong house, but since they were actually trying to do the right thing, hey, all is good, no cause of action. And the 11th Circuit had found yet another reason to deny Martin a claim, which was, second, the opinion below holds that the claims outside the proviso are barred by the FTCA's discretionary function exception because the FBI did not have stringent policies or procedures in place that dictate how agents are to prepare for warrant executions. I want you to think about that for a second, okay? The fact that FBI doesn't have significant policies as it relates to how to execute warrants, well, and that's very problematic for everybody involved. But number two, that then serves as the escape hatch by which the FBI can avoid liability. It actually encourages many agencies to operate with no written policies in place, doesn't it? Now, you heard the term discretionary function mentioned earlier. What does that mean? Well, essentially, what the Federal Tort Claims Act says is that, listen, if officers of government agencies are acting with some level of discretion, we can't really hold them liable for making mistakes. As the petitioners had pointed out in their original petition, the discretionary function exception bars claims based on the exercise or performance of a discretionary function. This precludes claims arising from actions that involve an element of judgment or choice and are based on consideration of public policy. But what the 11th Circuit apparently did not get the memo on is that way back in 1974, the statute was actually amended to add and provide methods by which there could be a cause of action for this exact type of behavior. As a matter of fact, the exceptions that were placed into the statute in 1974 specifically state that with regard to acts or omissions of investigative or law enforcement officers of the United States government, the provisions of this chapter shall apply to any claim arising out of assault, battery, false imprisonment, false arrest, abusive process, or malicious prosecution. Almost every single one of which was committed by the FBI in this particular case. Oh, and why was that actually added to the statute way back in 1974? Well, as it turns out, because of something exactly like this. Congress enacted the proviso in response to wrong house raids conducted by federal police in Collinsville, Illinois in April 1973. Now, the 11th Circuit actually used to read the statute correctly, but then once of these extra exceptions were added to it, thus providing these causes of action, well, the 11th Circuit just kind of took a left turn and went completely off the roadway. And they actually found in a case called Kardash versus United States that really there was no way of suing law enforcement agencies for this type of egregious activity. Kardash confirmed that in the 11th Circuit, the supremacy clause bars an FTCA claim if the government employee's acts had some nexus with furthering federal policy and could reasonably be characterized as complying with the full range of federal law. So understand, according to the 11th Circuit, as long as the activities, as unlawful as they may be, have some type of tangential connection to the core functions of that agency, they're essentially good to go. But you kind of have to ask yourself this, isn't this exactly the type of activity that Congress specifically wanted to see causes of actions when they amended the statute in 1974? The answer is yes, it is, everywhere in the country except in the 11th Circuit. Here, an FBI SWAT team committed a quintessentially negligent and wrongful act. It raided the wrong house. But the 11th Circuit denied petitioners any cause of action. The court began from the premise that an FBI agent has the discretion to do anything or nothing at all to ensure he raids the correct house because the FBI has no official policy or practice with respect to how agents are to locate or to navigate to the target address of a search warrant. And the 11th Circuit's holdings on the questions presented leave petitioners and the many similarly situated plaintiffs who will come after them entirely remediless. And I want you to think about the horrible public policy that underlying ruling in the 11th Circuit promotes, which is it literally encourages government agencies to not have written policies so that their agents and officers can operate in full discretion, and therefore, under the 11th Circuit's analysis, there's just no way for them ever to be put on a liability hook. But the plaintiffs in this case very wisely pointed out, Congress enacted the FTCA to accept federal liability for the negligent or wrongful acts of government employees within the scope of their office or employment. What Congress has given, the 11th Circuit has taken away. Yeah, the 11th Circuit's interpretation of the Federal Tort Claims Act is incredibly not only offensive, but massively problematic for anybody who resides in that jurisdiction. So if you live in any one of these states right here in the 11th Circuit, yeah, you are really, really rooting for Martin in the upcoming Supreme Court arguments. The 11th Circuit's interpretation of the Supremacy Clause defeats Congress's waiver of sovereign immunity through the FTCA in general, and the law enforcement proviso in particular. The 11th Circuit's rule usurps Congress's policymaking role and shields through sovereign immunity many, if not most, of the acts Congress intended to cover through the FTCA. It's almost like the 11th Circuit had to bend over backwards to try to screw potential plaintiffs. And as the petitioners pointed out here, as this court explained when interpreting the FTCA nearly 75 years ago, courts should not import immunity back into a statute designed to limit it. I mean, it's literally like the 11th Circuit, I don't know, had a result in mind and they were going to use whatever logic humanly possible to get to that result. Not like that would ever happen in the court of law, right? Why is this case so important? Because without a positive ruling from the United States Supreme Court, this type of abhorrent and ridiculous behavior from government agencies, well, it's likely to permeate throughout the rest of the circuits. And, of course, as the petitioners pointed out here, one of the incredible important aspects of this case is, given the entrenched, multifaceted disagreements among the circuits on the FTCA's interpretation, this case is as good a vehicle as is likely to come along. The core facts are clear. Their application to the FTCA is straightforward. This court has already provided its guidance on several related issues, and the questions presented are of great importance because they determine the extent with which the FTCA does and can waive federal sovereign immunity. Now, I want you to imagine what happens if Martin does not prevail before the United States Supreme Court, because not only will this family be out of any type of recourse or remedy for the FBI acting in such a negligent and reckless fashion, but so will people like our good friend Mark Manley and many other people who have been subject to not only the ATF and the FBI, but other runaway government agencies. If the American public cannot keep these agencies in check, there is nobody else seemingly willing to do it. Okay, the case once again is Martin versus the United States. We're going to go ahead and link up their original Supreme Court petition down below so you guys can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you just want to subscribe to our monthly newsletter, the ability to do all of that is down there in the description box. And then finally, and most importantly, let's remember the part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.